All right, let's talk about the one document that is basically a company's birth certificate, its rule book, and its entire DNA all rolled into one. I'm talking about the Articles of Incorporation. Now, I know, it sounds like some really dry legal paperwork, but as you're about to see, getting this one document wrong can have some pretty dramatic, even company-ending consequences. So let's get right into it. So let me start by asking you this. What single document is a corporation's fundamental blueprint? The one thing that defines who it is, what it's allowed to do, and frankly, whether it even legally exists in the first place. Well, that's the Articles of Incorporation, or as you'll hear it called, the AOI. I want you to think of the AOI as the literal constitution for a company. It's not a guideline, it's not a suggestion, it is the supreme law that governs that corporation's existence. It's the official agreement you file with the government that says, hey, we're here, we exist, and these are the rules we're going to live by. And as we're about to find out, those rules matter a whole lot. Okay, our first case study is a really powerful lesson about what is arguably a company's most recognizable asset, its name. This is a classic use it or lose it situation. So here's the rule from the SEC you absolutely have to know. When a corporation's term, the lifespan specified in its AOI, ends, it automatically dissolves. It's just gone. Now, it does get a 3-year grace period to kind of wrap things up, settle its affairs. But after that, its name, its entire identity, is completely up for grabs. So let's meet the players in this crazy legal fight. On one side, you have the original Filipino-Indian Chamber of Commerce, or FIC-CPI. Their corporate life just expired back in 2001. On the other side, you've got a brand new group that's on opportunity and, well, they swooped in to reserve the exact same name a few years later. And here's exactly where it all went wrong for the original group. You can see it on the timeline. Their term expired in 2001. The clock starts ticking. That 3-year protection period for their name, it ended in November 2004. And just 2 months later, boom, January 2005, the new group comes in and legally takes the name. This whole situation sets up a fascinating legal question, right? Can a corporation that is legally a ghost, it's dissolved, it's way past its grace period, can it somehow reach out from beyond the legal grave and still claim ownership of its old name? And the Supreme Court's answer was a huge, resounding no. The name was free for the taking. The big takeaway here is so important. Rights to a corporate name are not forever. They are tied directly to the corporation's legal existence. A simple oversight in their AOI, not renewing their term, cost them their entire identity. All right, let's switch gears. We've talked about a company's name. Now let's talk about its mission. What happens when a company does something completely outside the purpose it was created for? Well, this brings us to a really interesting legal doctrine called ultra vires, which literally just means beyond the powers. It really just breaks down into 3 simple steps. First, your AOI has to clearly state your purpose, right? Are you a school? Are you a restaurant? A tech company? Second, everything, and I mean everything, the company does has to logically connect back to that purpose. And third, any action that falls outside that stated purpose is considered ultra vires. And here's the kicker. The courts will probably refuse to enforce it. Which leads us to this really strange case involving the University of Mindanao. The university, which is an educational institution, mortgaged its own property to guarantee these massive private loans for 2 struggling banks. But here's the twist. The university's chairman was also the chairman of those very same banks. So the question for the court was pretty straightforward. Does an educational institution have the corporate power to act as a guarantor for a completely unrelated commercial bank's debt? Is that really part of its educational purpose? And wow, the Supreme Court could not have been clearer on this. In their ruling, they said the act had not even the remotest connection to the university's educational purpose. So the mortgage was declared ultra vires. It was completely unenforceable. It's just a stark reminder. You have to stick to the mission you laid out in your AOI. Next up, we're looking at something that seems like such a tiny detail in the AOI, but man, it has huge legal implications. And that is the company's official address, its principal place of business. Now, just check out the absolute mess this company created for itself. Their general information sheet said their office was in Pasig, but their original Articles of Incorporation said Manila. And then their amended articles said Makati. So if you wanted to sue them, where on earth would you even file the case? This led to a really serious accusation.
The people who were suing them, just to be safe, filed the exact same case in all 3 cities. This practice is known as forum shopping. It's basically trying to find a court that might give you the ruling you want, and it can be illegal. So the question was this an abuse of the legal system?
But the court said no, it wasn't forum shopping. And this is why it matters so much. The court put the blame squarely on the corporation for the confusion its own conflicting records created. Because the plaintiffs acted in good faith, they immediately withdrew the extra cases once the true address was figured out. They were in the clear. The lesson here is that every single detail in your AOI, right down to the city, has to be accurate and consistent. Okay, let's move on to our final case study, which answers a really fundamental question. When your own corporate documents disagree with each other, which one holds the ultimate authority? Which one wins? So here was the conflict. The company's stock and transfer book, which is basically a day-to-day log of who owns what, it showed only 165 shares had been subscribed. But its articles of incorporation, remember, its founding constitution, clearly stated that 776 shares were subscribed at its creation. Now, this difference was massive because it determined whether they had a valid quorum. That's the minimum number of shares you need to even hold a vote for a shareholder meeting. So the question becomes really simple. Which document is the final word? Is it the frequently updated logbook, or is it the foundational charter? The STB versus the AOI. Which one is going to win?
And the verdict was crystal clear. The AOI prevails. The Supreme Court established that the Articles of Incorporation is the primary contract between the corporation and its shareholders. It is the best and most reliable evidence of how many shares were subscribed at the very beginning. The logbook, it's secondary. The Constitution is supreme.
Okay, we've gone through some pretty intense cases, right? So let's try to distill all of this down into a quick and practical cheat sheet with the most important takeaways you really need to remember. First things first, why would the government reject your AOI in the first place? Just remember this little mnemonic, FPCP. Is the form wrong? Is the purpose illegal? Is the treasurer's certification false? Or does it violate Filipino ownership percentages? FPCP. If you get any of those wrong, you're pretty much dead on arrival. Next, let's talk voting math. You'll notice a pattern for the really big decisions. If you want to amend your AOI, invest outside your main purpose, or change your corporate term, you need a majority of the board plus a 2/3 supermajority of stockholders. But look at that last one. For an investment that directly serves your main purpose, the board's vote is enough. This is basically your guide to corporate power. So we end up right back where we started. The Articles of Incorporation isn't just some piece of paper you file and then forget about. It is the living blueprint for your company's entire life. It dictates your name, your mission, your address, and your power. So the final question you have to ask is yours built to last?